All right. You're listening to America's Voice Now. We're back. Thanks for riding with us. If you're listening to us on 99.3, Big Country 99, the Rooster Radio, welcome to the show. We're glad that you guys have joined us. We're here every night from midnight till 2. Happy to have you on board. You also can find our information by locally visiting us on our website and our Facebook pages. Those guys over at 99.3 are a great crew, and I'm really, really pleased that they're carrying AVN. The idea of a radio station that is kind of a country and rock station that is willing to carry news talk at night, and especially political news talk, is unique. And I'm pleased that these guys have been willing, and I'm honored that they've allowed AVN to participate on this program. So we do it after midnight so that we're not messing up everybody who wants to go out there and have a little bit of fun. But at the same point in time, I'm very, very pleased and thankful to those fellas over there. So Rick and Rocky, congrats to you. All right, we want to talk about this NSA court ruling thing, and I want to address the issue of what these court rulings mean. Yesterday, on Monday, a judge in Washington in federal court ruled that the bulk collection of the American telephone records that are being seized and captured by the National Security Agency is likely a violation of the U.S. Constitution. That's great news for us. There's a second lawsuit out there that we're going to talk about in a moment as well, but this first lawsuit actually already has a ruling in. The judge is Richard Leon. He was an appointee by the Bush administration, so he is theoretically of a conservative slant, one would assume. And to be honest with you, those of you who know and listen to this program routinely know that I take umbrage with the conservatives who, for all intents and purposes, are the ones who are selling us out on this. I mean, let's be candid. It's not the Democrats who have promoted the National Defense Authorization Act, the Patriot Act, and this NSA spying. In fact, those guys are the ones who are actually plying for us to be relieved of this abuse and tyranny. So that's why when you hear this program, I'm equally against both parties because they're both betraying us in some way, shape, or form. The liberals and the progressives out there and the Democrats, they want to betray us in a financial and fiscal and social manner in the sense that, we've got to constantly make amends to anybody who raises their hand and says, I've been slighted. We've got to sit there and under these social balance and equality laws, everybody's got to get the same thing, which doesn't really work because not all of us have the same skill sets and same capabilities and limitations and all the rest of that. On the other hand, you have the Republicans out there who are sitting there and promoting turning this into 1984 and some kind of a dystopian future. Well, I reject both. The truth is, I want both parties to start following the Constitution and stop treating us as if we are cattle to be bought, sold, branded, traded, and occasionally culled when we've outlived our usefulness. And that's the problem, ladies and gentlemen. Our government is operating now in a position where they have, for all intents and purposes, made us the subject, and we're no longer the master. In this instance, at least this judge has determined that, and by the way, he's used some extraordinarily harsh language. There's a 68-page ruling, which I've printed, but I haven't had a chance to read fully yet, and I will, I promise you, in coming days, so that I can really, because, I love that legal stuff. To me, I get a chance to read a legal ruling, and I enjoy that. I understand the language. I understand what they mean by it. And I like to look for the hidden little things between the lines, the little tidbits that nobody's thinking about, right? And, a lot of people look at that and they say, oh, my goodness, this is like trying to read, Chinese, Egyptian hieroglyphics written by a Greek. And I get that, too. Everybody's different, right? Some of us don't like that. I do. And when I read a ruling, I took my own case to the Sixth Circuit Court of Appeals and won. So, I'm fairly adept at reading legalese and legal language and rulings specifically. I enjoy that kind of thing. And I'm going to read it, I promise you, so that I can really give you the skinny on it and take a highlight marker and really hammer the thing out. I might even do a special program on that ruling as we move forward. The concern that I have, of course, is that this is at a lower court level, and it's guaranteed to be appealed, first and foremost, because the judge issued a stay. In other words, and a stay means that he's putting an injunction on the NSA saying you must stop monitoring the phone calls of the plaintiff and the plaintiff's client. Now, he stayed that, waiting for an appeal that he knew was coming. And he knows that this is going to go to the next highest court, which is the appellate level. And then after the appellate level comes the last stop, which is SCOTUS, right? Supreme Court of the United States. By the way, if you hear me refer to SCOTUS, you'll know what that means. It's the Supreme Court of the United States. And it's just easier to say SCOTUS. This is likely to make it to the Supreme Court. And if this one doesn't, the one filed by the ACLU, which we're going to talk about in a moment, will. And if that one doesn't, there was one, by the way, just the other day that the Supreme Court refused to hear, which I find utterly disturbing. And the reason I find that disturbing is because that confirms for us that the Supreme Court is or should not be construed and considered to be the final arbiter of our rights under the Constitution. Make no mistake about it, folks. These people in black robes, 9 of them, have made very, very serious mistakes in the past. And we are going to see, and the truth is, in some of those cases, they've overturned previous courts' rulings that have, corrected those problems. But in many cases, they have not. I mean, we're still living under Wilburn, or whatever the heck that one was, Wickard versus Filburn, where the Commerce Clause is basically opened up to be used for any kind of tyranny that the federal government wants to institute upon us. That was back in the 50s. So, or actually, I think it was even earlier than that. It was 47, if I'm not mistaken. So the point is this. This is going to get appealed, and we know it is, and he knew it was, so that's why he said, I'm ruling that the NSA has to stop listening to these people's phone calls. However, I'm going to hold off on implementing that ruling until this thing gets appealed up the hill. Now, Larry Klayman is the lawyer, and he was representing Charles Strange. Now, Charles Strange is the father of a cryptologist who was killed in Afghanistan when his helicopter was shot down in 2011. He was part of that SEAL Team 6 group that was, a lot of folks claim that there was a lot more to that helicopter accident than one would think. But one of the interesting aspects of this particular case is that the judge has made some statements in here which are noteworthy. And I'm going to give you a couple of snippets out of here. These are quotes from the judge himself, right? The government does not cite a single case in which the analysis of the NSA's bulk metadata collection actually stopped an imminent terrorist attack. Wow. Much to the dismay, I'm sure, of the NSA, that's a factual statement. They are relying upon a case that was in 1979 that says that any phone record that is created because it's already available to a third party, i.e. the telephone company who provides you the service, has no expectation of privacy. And this judge actually threw out a couple of things that were, basically saying, I'd be hard-pressed to rely on a 30-year-old opinion before cell phones were even invented. And congratulations to him for seeing the obvious. Another statement he made in here, which in his ruling, I found interesting. Plaintiffs have a substantial likelihood of showing that their privacy interests outweigh the government's interest in collecting and analyzing bulk telephony metadata, and therefore the NSA's bulk collection program is indeed an unreasonable search under the Fourth Amendment. Now, the truth is that these lawsuits are necessary. By the way, one of the stunning allegations that came out of this particular one, and we're going to talk about this in our next segment, but I want you to recognize that what was happening here. Larry Klayman, who's the attorney here, this is very, very interesting. He came out the other day in WND in an interview, and Larry Klayman, the WND commentary contributor and the founder of Judicial Watch and more recently Freedom Watch, told WorldNet Daily that once his allegations that the federal government was violating the Constitution with its watch every call strategy hit the courts, he noticed problems with his email. Listen to this. Quote, "People began receiving from me emails that I had never sent," says Klayman. "The government just wanted me to know they are watching me." I got to tell you, we're going to talk more about this, but that's a very disturbing thing. For those people who are out there sitting there and saying to themselves, well, I don't do anything wrong. What do I care if the NSA is listening in on my phone calls and reading my email and following my text messaging? What are they going to get? A bunch of I love you honeys and can you get milk and eggs and butter? Stop right there. If the NSA has access into your system and they can read all your emails, it stands to reason that they can also create them. And so if they need evidence against you and they need to manufacture some, don't put it past these people to do that, folks. I'm living proof of the fact that they can and do. So I'm telling you right now, if you make the mistake of thinking that that's something that you don't have to worry about, I beg to differ with you. Now, I just want to jump back to the story a moment because Judge Leon, in his decision, I told you this was a pretty scathing decision, right? 68 pages. It's a long decision. But he also wrote, I cannot imagine a more indiscriminate and arbitrary invasion than this systematic and high-tech collection and retention of personal data on virtually every single citizen for purposes of querying it and analyzing it without judicial approval. Wow. That's a pretty stunning admission. He also went on to say, the ubiquity of phones has dramatically altered the quantity of information that is now available. And more importantly, what that information can tell the government about people's lives. I cannot possibly navigate these uncharted Fourth Amendment waters using as my North Star a case that predates the rise of cell phones. You see, the truth of the matter is, folks, if you really want to talk about courts, this exposes one of the biggest scams going, and that is that courts utilize precedent to rule on cases. Well, the truth of the matter is, in a case like this, no court should be relying on a precedent for a case that's unrelated to this case, and they do. I mean, they hinge their arguments on the slenderest of spider webs and the most tenuous connections to say, well, this means that. The truth of the matter is, in court, de novo is a principle, and that's the Latin phrase for to look at first look. And all cases, by all courts, should never be ruled on based on precedent from a prior case, because that case is not the same case. And they almost always take these precedents and pull them out of context and misuse them. The truth is, every case before any court should always be looked at de novo on the constitutional basis for which it exists. In other words, there's no reason to go back to a case from 1979 that says that this guy's phone calls and 2 days' worth of his phone calls could be pulled up from his phone record to convict him of murder or whatever the heck it was. If you really want to understand what this means, go back and look at the actual Constitution and go back and look at what the founders had to say about privacy. And that's your answer, sir. That's your answer, gentlemen. That's your answer, ladies. That's your answer, court judges. You don't sit there and rule on precedent by some previous court, assuming automatically that that court was right. I would rather see you go back and look at the judicial precedents of what the founders said. How are you going to sit there and tell me that some judge who ruled in 1979 was more cognizant of constitutional liberties and freedoms than the founders themselves? Why don't you base your ruling on the foundation that the Constitution was built upon and the words of those people who actually wrote it? One, the Constitution and the wording within it itself. Secondarily, those words that were used to express and explain to the public what the Constitution was about. Those are the Federalist and the Anti-Federalist Papers. And they almost exclusively will deal with issues within the Constitution because those documents were both written by the founders, and there's a series of documents. Those documents were written by the founders to express and explain to the general population what this new Constitution thing was and what it meant. And to sit there and take precedent from a ruling that occurred in the 30s or the 40s or even 1800s and say that takes precedence over the intent of the founders, which can be found in their writings themselves, is a mistake. Now, I'll grant you, if you can't find a specific connection to the founders' writings, then you can maybe look at court at the weight of a previous court ruling. But the truth of the matter is, the vast majority of the weight in a ruling like this should not be based on a precedent. It should be based on the actual Constitution and the founders' intentions. That, ladies and gentlemen, is real constitutional law, not this mockery they put before us that says, well, you know, a judge ruled in 1936. I don't really care what that judge ruled. How do we know he was right? And that case wasn't relevant to this case. Not to mention the fact that arguing, and I got to tell you, the position of arguing that a case from 1979 that was in a criminal matter is vastly different than the case of saying that gives you plausible excuse to go out and monitor every American's phone calls. The use of the phone monitoring in that particular case was to identify who this individual was communicating with and to prove that he had pre-planned the crime. This is something completely different. And you can't sit there and draw a tenuous thread between those two and say, that gives me the right to do this. Right now, we're going to see this case get appealed. The second federal case that's out there is by the ACLU, and that particular case is going to be heard on Friday. I'm sorry, that was last Friday. They heard it. We're waiting for the judge's ruling in this one. Now, he didn't set a time frame for when he's going to announce his decision, but you know, I'm sure we'll see it in the next couple of weeks or whatever. Maybe even sooner than that. We may see it in the next 24 hours. I mean, there's no guarantee one way or the other. The ruling from both of these courts, because they're lower courts, are guaranteed to be appealed by the government because they have unlimited resources, and we know that, you know, they're gonna push this up the hill. But the case and the situation in this case is being filed by the ACLU itself, and they're arguing for a preliminary injunction to bar the NSA from the collection of all Americans' phone records. So, the question is, some of these cases have actually made it in here, right? The landmark ruling that they're utilizing was called Smith versus Maryland, and it was in 1979. And I found that particular, and here's why I tell you that the connection is extraordinarily tenuous. That was a criminal defendant's case. In other words, the guy was accused of committing a crime. And because of that, he didn't have a reasonable expectation of privacy over the list of the people that he had on his, or the phone numbers that he had dialed within that 2-day period that they were trying to prove that, you know, he had pre-planned or masterminded this crime. It is the one aspect, and that is the one case that both of these cases are hinging on. In other words, the government is hanging its hat on Smith versus Maryland. Well, let me tell you, That's a pretty tenuous connection to basically abuse the Fourth Amendment liberties of every American who hasn't yet been accused of anything. And the truth of the matter is, the vast majority of Americans are not guilty of anything. Now, there have been other cases here, including the Supreme Court's 2012 case of U.S. versus Jones, where that court said that there are limits that can be placed on the police use of GPS tracking. And that, ladies and gentlemen, would be a more appropriate, an appropriate connection, if you will, than the Smith versus Maryland case. So anyway, we're going to wait and see what happens with this. We don't know where either of these cases is going to go. What I want you to be aware of is, one, that this isn't just laying fallow somewhere and nobody's paying attention to it. While we are outraged as a nation, the truth is that there are people who are taking some legal action to try to contend and fight this thing and contend with it and fight it. And I applaud their efforts. I'm very happy that they are. The truth of the matter is, it would be wonderful if we could get an entire, class action lawsuit based on or on behalf of every American. Now, of course, one of the problems is that these judges who are ruling in this have concerns about whether they can override the FISA court, right? The FISA court. But the arguments out there are that the FISA court is acting, one, in secret to begin with, so nobody really knows what they're doing. And the truth of the matter is, the FISA court has already ruled repeatedly that what they're doing exceeds their authority under the Constitution. There's an article out there from the Guardian on some of the claims that were made in the 60 Minutes piece which is, I have to tell you, it was flat out, straight up, hardcore propaganda promoted by CBS on their 60 Minutes, where they did this, expose on the NSA, and they made these NSA people. They let them put all their arguments forth, but they never asked them any hard questions. Every question was a softball that was teed up to allow them to basically explain away why and how and what. Now, one of the issues that they did talk about, excuse me, was this issue about whether or not the NSA is violating the FISA court rules. And I got to tell you, there are two different FISA court judges who have come out and said that they have raised major concerns about the way the NSA is utilizing these vast data troves and how they've gone through them on multiple occasions. In fact, this one judge, Bates, found that virtually every record generated under a now-defunct NSA program that collected Americans' internet metadata in bulk included information that, quote, was not authorized for collection. So to sit there and try to utilize the FISA court and say, they have authority, the real reality of it is this, and here's one of the scariest parts about this. The truth is, the court's judges themselves have said repeatedly, we don't really understand the technology well enough to be able to independently determine, one, how these NSA programs work, and two, if what they're collecting is actually as voluminous and dangerous as everybody thinks they are. And so there's no way for them to really tell, this is the FISA court now, if they are in compliance with the limits that the law has already imposed on them. There's no way to police it. And so here's the problem. They're left at the mercy and left to make a decision based on the NSA's own assertions that they're doing the right thing. And they're left with the situation where they must accept that if there's a problem, the NSA will turn itself in and say, hey, you know what, we overreached in this case and we just wanted to let you know about it so that, and we've already taken steps to correct it. Well, what about the times when they don't self-report? The truth of the matter is, there's no court, and especially not a secret one, that is capable of making those kinds of determinations. And I got to tell you, There is no way that a FISA court should be secret in the first place. That's inexcusable, and it's inconceivable that that would be in any way or correlation acceptable under our Constitution. You've been listening to America's Voice Now. We're going to take a quick break. When we return, we're going to talk about the NSA plaintiff emails that were sent, apparently, without his involvement. That's a very scary thought, isn't it? This is the guy who was the plaintiff in this case, and we're going to talk about it because that's a scary thought. If this guy has got emails going out of his account he didn't send and text messages coming from him he didn't send, wow. That throws a whole new light on this. We'll be right back.